Testing, testing. Melissa, can you hear us? Testing, testing. Testing, testing.
Relax, it's good. Her phone just kept getting.
Okay, wonderful. We are officially live.
Just saying that we can't see the face down.
Yep, it's going to be like this. We're going to put the podium right here.
Do you mind coming in here?
Theme
Oh, you're talking to me.
Sorry. Sorry. I'm sorry. That was like I was summoning you. I'm sorry. We're running just a couple minutes behind. But what the judges need to do.
I just didn't want to assume.
I'm always talking to the person. Yeah, we got that's why I want to just different.
Everyone, just be conscientious that we are currently live on YouTube, so make sure that the audio is crispy clear. Yeah. Everyone, start coming in.
Yeah, keep
What are you? Yes. So, I need the lecture to confirm it. So all of our viewers at home, currently we have 37 viewers. We're going to be starting momentarily. Thank you so much for joining us. We've got Matthew Lapari. He's saying good luck, Brandy. She'll come back. Yeah, she's in the chat now. Maybe you could send them. We have people in the chat. They're saying good luck today. We currently have 40 viewers. Brandy, they wanted to let you know in the chat, Lindsay wanted to say congratulations, James Sawalski, England, and Lang. Some of our competitors are in the chat, they're cheering you all on.
Thank you.
Sure, we're not review. Chief Judge, Melanie May.
Good morning, everyone. Welcome to Back in Person. This is the final round of the 2022 Moot Court Society, Honor Society Feinrider Competition. For those of you that don't know me, I am Professor Heather Baxter. I am the faculty advisor for Moot Court, as well as the LRW director. And I am so excited to welcome you all back in person here. It's so nice to have an audience here. It's been a difficult couple of years being online, but one of the positive things is we learned this wonderful ability to be also live and online. So we're delighted to be live streaming this to all of our YouTube fans. It's been a wonderful weekend of advocacy here at Nova. And we started on Friday with our LRW oral arguments. And we heard time and time again from judges about the incredible talent of this first year class, which is in no doubt directly related to our fabulous LRW faculty. If you're watching online, some of you, thank you so much for our top 15 ranked LRW faculty in the country. So, preparing these students. And so then I believe that our Moody mentors too, I want to give a big thanks to our Moody mentors. All of the Moot Court 2Ls and 3Ls that have spent all weekend here laboring, getting food, judging, bailiffing, all the time they do. Big round of applause. Because of our 4 executive board members. So I want to take a huge moment to congratulate Kelly O'Neill as our Chief Justice. Dorsey is our Executive Justice. Contreras is our Executive Justice of Peace. And last, but certainly not least, the woman of the hour, Lakshmi Apollinario. Judges, both real and pretend this weekend. We are so grateful for your time and your ability to come back in person and judge these students. We are so grateful for that. So a big round of applause for our judges. want to thank the Dean, Beto Lores, who's going to come up and speak to you in just a minute, for his tireless support of our moot court program as well as our LRW program. And without, all of this would not be possible without his support. So thank you. Dean, I'm going to turn it over to you.
I have to begin by apologizing to the judges. I've never, ever put my back to in a court, so I feel a little bit uncomfortable. I'm going to be brief because I know we're all anxious to see this competition. First of all, I want to congratulate the finalists, but I also want to congratulate every single student who participated in this competition. It really is remarkable the amount of work that's involved in putting something on like this kind of a competition. And that, of course, includes many, many hours of work for the competitors as they prepare. And we're going to be very fortunate to see the finalists showing us their preparation and their skills. And I'm really looking forward to seeing that. I want to note very briefly, and I'm going to look down because I want to make sure I don't forget a single member of the main member of this law firm. We are in the Krupnik, Campbell, Malone, Buser, Slama, Hancock courtroom. And I usually talk about it as the Krupnik Campbell courtroom because that's a whole lot of names to keep track of. But I do want to note that we are in this state-of-the-art facility. The Moot Court Honor Society has done an extraordinary job ensuring that those who are participating online are able to hear and see everything. And so I'm very grateful for all the work that has gone in connection with that. And then I want to note that we are, of course, the number 15 Legal Research and Writing Program. To the amazing work of our LRW faculty. And I'm so grateful for all that they do. And of course, one of the key things about a competition like this is that it's emblematic of what we're about at NSU Law. We aren't just about theory and just about looking at the cases and talking about what happened in the written cases, but also about experiential learning. And this is a great example of how we conduct that experiential learning. And I'm so proud of all that we do in that area, but especially glad that we have the Moot Court Honor Society, which takes its role so seriously under the tutelage, of course, of Professor Heather Baxter, who just doesn't ever stop working as far as I want to thank all of our distinguished judges. They range, a number of them are our proud alums, of course. Some of them are actual judges. Some of them are advocacy professors. They are all very accomplished advocates, including, I will note, Chief Justice O'Neill, who will also be part of the judging panel. So with that, I am going to sit down and I am going to enjoy watching. I don't need to be disrespectful to our finalists if you see me enjoying as you are being interrogated. That's not rather to see the great work that you all are going to be doing. It's going to be so great and so much fun. Thank you all very much for being here.
And I will be brief because I know we're all very excited to get this underway, but a big thank you to Dean Juarez for joining us. I know it means so much to our competitors, it means so much to the society to have your support and that you're here. We sincerely appreciate it. I will not repeat much, but I do have to repeat a very emphatic thank you to our Moot Court members for making our first in-person competition in 2 years run as smoothly as it did. That would not be possible. That would not have been possible without all of the help and support and hard work of our current board members, most especially Executive Justice Lakshmi Polnario for competition. She is fantastic. Behind the scenes and anywhere you can possibly think of. But importantly, it would not be possible without the help of our incoming board. So I'm going to take a moment to introduce our incoming board members. We have our incoming Chief Justice, Kelly Mira. Incoming Executive Justice for Competitions, Melissa DeSantis. We have our incoming Executive Justice for Academics, Rachel Trotwell. Incoming Executive Justice for Teams and reigning Feinrider champion, Jordan
Yes,
Stein.
yes.
We cannot wait to see all that you accomplish in the next year, and I can't wait to come back and judge this again. So, I'm going to turn it over to Lakshmi, and we're going to introduce the judges and then get this started.
Hello, and now for the moment of truth. Hello to everyone at home as well. It's an honor to be able to have a hybrid streaming of this live final round. First and foremost, I will introduce our competitors. We have the movement, Ms. Brandy Permenter. You may stand. Our non-movement, Mr. Nicholas Carroll. Phenomenal job. And now for our distinguished final panel. So we'll begin with Mr. Harvey Suppler. Mr. Suppler is an appellate attorney and assistant public defender for the 11th Judicial Circuit, who has been practicing for over 30 years and has litigated over 1,500 criminal and civil appeals in front of both the United States and the Florida Supreme Courts. He has taught at several law schools in Florida, including NSU, St. Thomas University Law School, and the University of Miami, where he obtained his JD. The Honorable Chief Judge Melanie May. Judge May has served as a judge for the Florida 4th District Court of Appeals since 2002, where she currently assumes the position of Chief Judge. She received her bachelor's degree from Florida Atlantic University, Go Owls, and she obtained her JD from Nova Southeastern University, Shepherd Road College of Law. Woo! Mr. Robert Shepsky, he is an attorney practicing in the areas of commercial litigation, employment law as an associate at Tripp Scott, where he first joined the firm as a summer associate and was subsequently offered a position after graduating from the NSU Shepherd Road College of Law. He graduated from Nova with a summa cum laude, and then he also served as Moot Court's very own Chief Justice. Ms. Hillary Creary, she has been practicing for 25 years. She specializes in family law. She currently sits in the Florida Bar Board of Governors. She is also the chair of professionalism panel for the Broward County. She is a two-time Nova alumni. She received her JD and her bachelor's degree from Nova Southeastern University. And she is actually the Feinrider champion from her 1LU. Champions in the room. And last but certainly not least, our Chief Justice, Ms. Kelly O'Neill. She currently serves as our Chief Justice, and she graduated from the University of Florida Honors Program, cum laude, dual major in political science and Spanish. She is a national competitor for Moot Court, where she recently, almost 72 hours ago, competed in the ABA National Appellate Advocacy Competition. Kelly and the team, including Jordan and Jonathan, they advanced to the top 16 of the national rounds just yesterday, and they also received the second best brief in the nation. I would like to call the case to our, I'm so sorry, and may our bailiff. Apologies, and let me just grab the phone and we can take a seat and then the bailiff will call.
Good afternoon and welcome to the final round of the 1L Feinrider Competition. All rise. The Honorable, the Chief Judge, Ms. Melanie May, Associate Judges, Judge Harvey Suppler, Judge Hillary Creary, Judge Robert Shepsky, and Judge Kelly O'Neill. For the United States District Court of the District of Massachusetts. Oyez, oyez, oyez. All persons having business before the Honorable Court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this Honorable Court.
Please be seated.
Ms. Permenter?
You may proceed when ready.
Will you be reserving time for rebuttal?
Yes, please, can I reserve a minute?
Yes.
May I proceed?
Yes, please.
Chief Justice May, Your Honors, may it please the court. My name is Brandy Permenter, and I represent the movement, Mr. David Jones. We respectfully request that you grant the defendant's motion for a new trial pursuant to Federal Rule 33 of the Federal Rules of Criminal Procedure for the following two reasons. First, the defendant was prejudiced by his counsel's deficient behavior. Second, the public policy supports the adoption and application of the presumed prejudice test. The presumed prejudice test was formulated by the Supreme Court in United States v. Chronic in 1984. It developed a two-part standard where first it evaluates whether counsel was absent for substantial or critical portions of the trial. Substantial portions was stated in United States v. Reagan as to be evaluated on a case-by-case basis by taking into consideration the duration of the trial, the amount of time counsel was asleep, and how substantial that portion was.
Let me just ask you this. If we do not agree with you to adopt the presumed prejudice test, where is the actual prejudice in this case?
Actual prejudice is in this case because under the actual prejudice test, you have to prove prejudice that but for the counsel's deficient behavior, the outcome of the trial would have been different. Here, we can prove that the outcome of the trial could have been different because of we are unsure as to whether the objections that the defendant's counsel could have made or should have made would have changed the outcome of the trial. For example, there was damaging evidence permitted into the legal proceeding when that damaged the defendant's case, while this should have been objected to by defendant's counsel and should have not been admitted into evidence if she did properly object and would have potentially altered the outcome of the trial. And this is based off of a reasonable probability. A reasonable probability is a likelihood sufficient to undermine the outcome of the legal proceeding. There's a reasonable probability that her absence during these times could have altered the outcome of the trial.
Counselor, can you go into the specific details of when this could have happened, when this prejudice occurred?
So counsel was seen sleeping on 4 occasions. First, I'd like to point you to Judge Smithson's affidavit, paragraph 2, where he stated that counsel was seen sleeping for about 5 minutes during Special Agent Walter's testimony. Again, she was alleged to be sleeping during the testimony of Miss Emily Broadway, in which defendant had to nudge his counsel to wake up. And then on the third instance, she was asleep for 15 minutes of Special Agent Montiel's testimony, in which she was admitting damaging evidence against the defendant. And then she was also seen sleeping for 40 minutes during the playing of a video that was entered into evidence as well.
Excuse me, Counselor, isn't it true that that was a video that Ms. Stamp had previously viewed on multiple occasions? So perhaps she didn't need to be seeing it, right?
Yes, Your Honor, but however, this is, while she had seen this previously, this could still be deemed as a critical portion of the trial. She needed to be aware whether there was any alterations or deletions to the video. And so she should have been attentive to make the proper objections or state that there had been a change from this video that she had seen. Because she was absent for 40 minutes of this video, she's unaware as to whether there was an alteration during this time. This present case is similar to Tippins v. Walker in the Fourth Circuit.
Counselor, let me just interrupt you. It seems to me you've got a two-part hurdle that you have to surmount. The first thing is that a reasonable attorney would have done the things that you said weren't done here, object or whatever it would be. And the second thing is that hurdle you have is the reason that there was no objection is because counsel was sleeping or inattentive, as opposed to some type of strategic decision not to object.
Your Honor, there's 2 different tests to be applied here for ineffective assistance counsel claims. So in the actual prejudice test, you would ask whether the counsel's deficient behavior altered the outcome, but under the chronic test, which is the one we are advocating to be applied and adopted in this circuit, ask whether their counsel was absent for substantial or critical portions first, and then a rebuttable presumption arises to where the prosecution has to rebut the presumption of prejudice once the defendant has shown that their counsel was absent for substantial or critical portions of the trial. So if I'm understanding your question.
I think so, but I'm a little troubled. Supposing instead of, just for the sake of argument, counsel, instead of sleeping, counsel was writing notes. She was listening to what was going on. She was writing notes and she didn't object and she didn't look at the video and she didn't do all those things. wouldn't we really be in the same position we're in now?
Under the chronic test, the presumed prejudice test, we would not, because here we are evaluating when she was absent. And here we can make a reasonable inference that she was asleep because she had her eyes closed for over 40 minutes. She made mention, and it's in, if I could point you to the trial transcript on page 8, line 357 to 361, that she mentioned how she had a lack of sleep and she missed her alarm clock. So we can make a reasonable inference from that evidence that she was sleepy and tired going into this legal proceeding, and she did in fact sleep when her eyes were closed during these 4 instances. So it would not be the same as her writing her notes and staying concentrated. It is clear that she was absent during this time, and it's even more clear as the trial record reveals that she was not actively participating during these times. She was not.
That's your question, President. I don't want to. Does it at all trouble you with the fact that trial counsel was privately retained? And anywhere along the line, counsel thought, the client thought that counsel was inattentive because she was sleeping, he could have asked to remove her and get a new lawyer, but that didn't happen here. Is there any problem with that?
No, Your Honor. I believe the defendant would be apprehensive to retain a new counsel in the middle of trial. He nudged his trial during Ms. Evelyn Broadway's testimony, and he made note of this to both the bailiff and the judge. So he put it on record that he sees his counsel sleeping. However, it would not be advantageous for him to receive a new counsel in the middle of the legal proceedings. So under this circumstances, we are able to presume prejudice because he made note of this, although his counsel was privately retained, that she was absent for substantial and critical portions. Additionally, the public policy of the Sixth Amendment supports the application and adoption of the presumed prejudice test because sleeping counsel is no counsel at all. And under the Sixth Amendment, criminal defendants are entitled to the right of counsel and of effective counsel as stated in McMahon v. Richardson and Strickland v. Washington. So under the public policy of the Sixth Amendment, there are situations that are so egregious to when counsel is absent that they have received no counsel at all and has undermined the Sixth Amendment, and they should be entitled to a new trial pursuant to Rule 33.
But Counselor, we talk about sleeping, and there is no direct evidence in this case that Ms. Stamp was asleep, correct?
Yes, Your Honor. However, we can make a reasonable inference from the facts that she had her eyes closed for 40 minutes during a movie and that she made mention in trial transcript page 8, lines 557 to 561, that she had missed her alarm, she was tired, and she had her eyes sleeping during this 40 minutes and 15 minutes during Special Agent Montiel's testimony.
Counsel, I've got a question. So there are lines of cases that we need to rely on here because this is in fact a case of first impression in our circuit, correct?
Yes, Your Honor.
And so I think it's the fourth, the fifth, the second, the fifth, the ninth circuits have a line of cases. The fourth has an additional line of cases. So what is our role here today in figuring out which line of cases need to be adopted here?
From the First Circuit actually made a recent ruling in 2021 in United States v. Baptiste that stated that the overwhelming evidence test as adopted in the actual prejudice test is not always appropriate and does not negate an ineffective assistance counsel claim. Right to counsel is granted to both the innocent and the guilty. And this was adopted in the First Circuit, the circuit we are sitting in today. So that gives some insight as to what ruling it should make and that the actual prejudice test is improper and the presumed prejudice test would be appropriate in this instance because the counsel being asleep during this legal proceeding is so egregious to allow for a presumption of prejudice to arise.
Counselor, in the United States v. Baptiste, that wasn't a sleeping counsel case. So how can we make that jump that this is the proper standard if the case really isn't on track or on par with the cases at par?
Yes, Your Honor. Both tests under the Strickland v. Washington and chronic were not derived from sleeping cases. They were both for ineffective assistance of counsel cases where counsel is absent. So this is why it would still be appropriate, although in United States v. Baptiste it was not a sleeping case. Your Honors, I see that my time has expired. May I briefly conclude? Yes. We respectfully request you grant the defendant's motion for a new trial pursuant to Rule 33 of the Federal Rules of Criminal Procedure. Thank you.
Thank you very much. Mr. Carroll?
Court. My name is Nicholas Carroll, and I represent the United States, the respondent in this matter. I respectfully request that this court deny defendant's motion for a new trial for 2 reasons. First, defendant has failed to establish that defense counsel's performance at trial presumptively prejudiced the outcome of the trial. And second, because there's no evidence that defense counsel's performance at trial actually prejudiced the outcome of the trial.
Does it matter to you whether we apply the presumed prejudice or the actual prejudice test to resolve the motion?
No, Your Honor. Defense counsel has failed to establish either test. The Sixth Amendment of the Constitution guarantees every criminal defendant the right to counsel. The Supreme Court, in the case of Strickland versus Washington, further explained that the right to counsel means the right to effective assistance of counsel. The court, in that case, laid down a 2-pronged test that every defendant seeking to claim an effective assistance of counsel must meet. First, the defendant must establish that counsel's performance at trial was deficient. Second, that such deficient performance prejudiced the outcome of the trial. As Your Honors may know, the trial court has already ruled on the issue of deficiency, and so the dispositive issue in this motion is whether or not defense counsel's performance prejudiced the outcome of the trial. Now, the court is
Does the record tell us when the trial court has found that there was deficient performance, can we assume that was because of these allegations of sleeping, or maybe it was because she didn't object or other things like that? Can we tell from the record on what basis the trial court found that there was deficiency?
Your Honor, the record is not clear, and I do not have the benefit of the trial court's ruling and the reasons for the ruling. However, that issue is now moot at this point, and the dispositive issue for this court today is whether the deficient performance that has already been found by the court prejudiced the outcome of the trial. Now, the court in Strickland noted that there are 2 types of prejudice that can satisfy the test, either presumed or actual, and in this case, neither type has been proved. In the Supreme Court case of the United States versus Chronic, the court held that prejudice may be presumed in certain limited circumstances, such as where there has been a denial of counsel during critical stages of the trial, and where there's been a constructive denial of counsel, which occurs where the prosecution's case is not subjected to meaningful adversarial testing. Now, this test that was laid down in Chronic was applied in the case of the United States versus Reagan, where the court was faced with this ineffective assistance of counsel claim based on allegations that counsel was sleeping. And in that case, the court found that there was a presumption of prejudice because there was evidence that counsel was sleeping every day of the trial, in the morning and in the afternoon, for 30 minutes at a time, sleeping through important testimony and failing to
Does it really make a difference? Going back to what I was asking you before, does it really make a difference why counsel's performance was deficient? Supposing a reasonable defense attorney would have objected to certain evidence. We're not going to talk about evidence here, but I mean, just generally speaking, if a reasonable attorney would have done those things, and if that wasn't done for whatever reason, we don't really need to be focusing on sleeping. Maybe what we should be focused on is whether a reasonable attorney would have not done those things. We don't need to deal with this whole sleeping attorney morass that we have.
Yes, Your Honor. I believe that in the first prong of the Strickland test, where the court is examining whether or not defense counsel's performance was deficient, that analysis would take place under that portion of the test. But in this case, that has already occurred. The court has already found that defense counsel's performance was deficient. And Your Honor, in this case, unlike the case United States versus Reagan, there is no evidence on the record that counsel was sleeping at any point during the trial. On the contrary, there is an affidavit from trial Judge Smithson, where he expressly states that he did not see counsel sleeping, and had he seen her sleeping, he would have done something.
Well, Counselor, excuse me, but isn't there also evidence in the record that trial judge did express to Ms. Stamp during testimony that, hey, perhaps you should be objecting right now? Isn't that cause for concern? And that is evidence at the very least of ineffectiveness and perhaps at most sleeping, is it not?
Your Honor, I am not aware of anything on the record where the trial judge said to counsel that she should object. However, assuming that counsel was sleeping during the trial on every instance alleged, defendant still has the burden of proving that such sleeping occurred during critical moments of the trial or for substantial portions of the trial. And in this case, that burden has not been met by the defendant.
Why not? Why not? I mean, these were critical, as I understand the record, these are all very critical witnesses to the prosecution. Why hasn't that been determined that there was this presumed prejudice? Could you have, could you have made your case without those witnesses testifying?
No, Your Honor, the
They were
prosecution,
critical.
they were critical, there were critical witnesses, Your Honor, but the court in Strickland and the court in Chronic, as well as the court in Reagan, in the second counsel case, stated that the defense counsel has the duty to point out the exact errors that occurred and show how if those precise errors did not occur, the outcome of the trial would have been different. During defense counsel's presentation, the argument was put forward and the evidence was characterized in such a way that it appeared as though counsel was sleeping through the entire evidence or the entire testimony of the prosecution witnesses, but that's not the case. The record shows that defense counsel was objecting and the defense counsel cross-examined, for example, the IRS agent for 3 hours. And so under the rule set down in United States versus Chronic, the court held that the overarching consideration that this court must have when examining these ineffective assistance of counsel cases is whether the defendant received a fair trial.
So Counselor, what constitutes as a substantial portion? Because it seemed like the movement referenced 4 to 5 different instances where during the critical portions of the trial, the counsel was asleep. So what is that substantial portion that we need?
Yes, Your Honor. The court in United States versus Reagan held that substantial portion in this context can refer to 3 characteristics. It can refer to the length of time sleeping, the proportion of the trial missed, and the significance of the moments that were that counsel was asleep. I respectfully submit that the defendant has failed to establish that the facts in this case fit into any of those categories. There is no the incidents of sleeping did not occur during critical moments of the trial, and if Your Honor would like, I can go through them one by one to show how that's not so. For example, in the first instance on the first day of trial, defense counsel had her head down for 5 minutes. Even if she was sleeping for those 5 minutes, I'm sure the court would agree with me that 5 minutes is an inconsequential amount of time, especially considering the evidence that was being led at that moment. At that moment of time, background evidence about how the IRS approaches these criminal tax evasion cases was being led. It had nothing to do directly with defendant's guilt or innocence. And the court in Burdine versus Johnson held that critical moments of the trial are moments where evidence is being led that concerns the defendant's guilt or innocence.
But you've already told us that these are the critical times. These are critical witnesses for the prosecution. And I want to add a third thing. You kind of laid out 2 different factors. Maybe there's a third. What message does it send to the jury when the defendant's own counsel is sleeping during critical witness testimony?
Yes, Your Honor. First, I would like to reiterate that these are allegations of sleeping. They have not been proven. There is not sufficient evidence on the record I would respectfully submit in light of the trial judge's affidavit. However, even if we assume that counsel was sleeping, although the prosecution witnesses were critical, the key fact that this court must examine is at what portion of those prosecution witnesses' testimony was counsel sleeping. She certainly was not sleeping for the entire duration of the testimony, because the record shows that objections were made throughout the testimony of the prosecution witnesses. Specifically, Your Honor, there may have been objections that could have been taken during the prosecution witnesses' testimony. However, the court in Strickland noted that in ineffective assistance of counsel claims, the court must pay deference to trial counsel's strategic decisions, because it's very difficult to analyze whether or not they were appropriate in hindsight.
Assuming that these were strategic decisions. They may not have been.
Yes, Your Honor, they may not have been. And even if they were not, even if there was an objection that should have been made, I would respectfully submit that the damaging evidence would have come out anyway through other witnesses.
How do we know that?
Because it did. Because, Your Honor, during the testimony, Your Honor, I see my time has expired.
Go ahead and finish the question with your answer for the question.
Yes, Your Honor. There were opportunities for the counsel to object to questions relating to Mr. Jones's intention not to file his income tax returns, which is one of the issues in this case. Although defense counsel did not object during the IRS agent's testimony, that same exact evidence came out from the defendant's CPA, the evidence relating to the defendant's willful failure to file his income tax returns. And so whether or not that objection was made, the evidence would have come out anyway. Your Honors, for those reasons, I respectfully request that this court deny defendant's motion for a new trial because there was no evidence of actual or presumptive prejudice.
Thank you, Mr. Farrell. Mr. Medic? Yes.
Ensuring the protection of one's Sixth Amendment right is crucial to ensuring that their other rights are protected, such as their right to life, liberty, and the pursuit of happiness. The public policy behind the presumed prejudice test ensures this. The United States has already conceded that either test could be applied, and here the presumed prejudice test is appropriate. The United States stated that there is limited and egregious instances where prejudice should be presumed, and this is that instance. This case is similar to Tippins v. Walker, where presumed prejudice was found when 4 out of the 5 witnesses attested to seeing defendant's counsel sleeping or absent during this legal proceeding. Additionally, counsel was absent during the admission of evidence that was damaging to the defendant's case. This has shown that there's been substantial and critical portions at which defendant's counsel was absent, proving that there should be a presumption of prejudice. Your Honors, my time has expired. May I briefly conclude?
Yes, please.
We respectfully request that you grant the defendant's motion for a new trial pursuant to Rule 33 of the Federal Rules of Criminal Procedure. Thank you.
Well, that was absolutely phenomenal.
Chills. Chills.
Gave me the chills. The judges and I are going to return to, we will deliberate for the round, and we will return for feedback. We will be as brief as possible, but in the meantime, you are in the very capable hands of our Executive Justice for Competition, Zachary Polinario. And thank you all so much for joining us. For those of you online and for those of you in the courtroom, it's quite an experience. Thank you.
It's really good. I feel like I'm in the competition. I just want to say that I'm glad I don't have to make the decision. I'm so glad it's not me. Wow.
Okay, so I do have a couple of announcements to make while they are deliberating. We're not done here just yet. So first and foremost, I want to say hello to all of the viewers at home. We do have approximately 50 people watching this right now, so congratulations. It seemed there was a lot going on in the chat, and we'll touch on that. First and foremost, I do want to show the viewers at home our champion and runner-up trophies. This is essentially the coveted title that they are going to be competing for. Hey, everybody. Furthermore, we wanted to unequivocally thank the Themis Bar Prep course. If you're not aware, you will be winning a Themis Bar Prep course. If you make it to the top winner wins a famous bar prep course. That is an invaluable opportunity. That course actually costs almost $2,000. And even though you don't have to worry about that now, when you get to 3L year, you're not gonna wanna spend that, you know, especially after all the years and all the difficulties that you have faced. So I do have a couple of questions. I do want the competitors to just stand up for 1 minute and just tell me a little bit about yourself, because everybody wants to know who you are, and just tell us a little bit about yourself, please.
Hi, my name is Brandy Permenter. I actually went to Nova for my undergrad. I did legal studies and sports and recreation management. I also played on this women's soccer team at Nova. And I'm from Orlando, Florida.
Where are you from? You were born in Florida?
Orlando.
You were born in Orlando? Yep. Fantastic. And what made you want to go to law school?
I don't really know. I think from 6th grade, I just knew I wanted to go to law school.
You wanted to be an attorney since you were in 6th grade?
Yep.
And what made you, what inspired you to want to become an attorney?
I think first I watched Jerry Maguire, and I was like, oh, I want to be I don't know. It kind of evolved from there.
That's fantastic. Thank you, Brandy. Please stand. Tell us a little bit about yourself.
So I'm Nicholas. I was born in Guyana. I was raised in Barbados, two countries in the Caribbean. I recently migrated to the States in the middle of the pandemic, March 2020.
And what made you want to do that?
Migrated to the United States. Is this being recorded?
We're live.
Yeah, well, I don't really want to go into it too much, but I just felt there are a lot of opportunities here. There's opportunity to help develop my country and push things forward if I get education in the United States, and I create a base for myself here. I'm an attorney in my own country. I've been an attorney for a few years. And when I moved over here, I was not initially intending to go to school because I have some other business interests at home and so on that I engaged with. But,
and how did you know about Nova Southeastern University?
well, I was working with an attorney in Miami. He was basically telling me that it would be a crime if I don't go to law school. And so, here I am, and it's been an amazing experience so far. This, coming from the Caribbean, it's tremendous to have all these resources and facilities that, for me, is incredible. But I can see that, some people it's like normal for them. But I'm just so happy and honored to be here at this school and in this competition.
Yes, thank you. Phenomenal. Okay, so we have a lot of viewers, as I have been mentioning. This is the first time, I would like to add, that Nova Southeastern University has streamed a live competition on YouTube in person. So we've had a hybrid event, hybrid year, and so this was a fantastic opportunity. I'm honored to have been able to plan this competition. A lot of people don't know that originally the Feinrider Competition was going to be on Zoom. And unfortunately, we ended up pivoting through the guidance of Professor Baxter and Dean Juarez. It took a lot behind the scenes, and I was grateful that once we got the clearance to be able to have this opportunity, the entire Moon Court Society essentially got together, and we have been working endlessly and tirelessly to make this happen. And ultimately, it was always about the 1L class and making sure that that opportunity was given to you 100%, and that you were able to take advantage. So I'm honored. Were you able to take advantage of some of the practice sessions? Were you able to have a Moody mentor? What type of resources were you able to use throughout your process while you were practicing?
I used a Moody mentor at George Pena.
George Pena, fantastic. Yes, that's awesome. Did you practice on Zoom? Did you practice in person? How did that process go for you?
We practiced in person here at school.
You practiced in school, that's fantastic. And what about you?
Yeah, I also was assisted by a multi-mentor. It was Farida.
Farida.
Yeah, it was really amazing. She was so helpful. There was a group of us that she was assisting. Farida was at school past midnight every day to assist, where we need help.
That's fantastic. It was our goal to make sure that we provided the 1L class with as many resources as possible. First, we paired the competitors with Moot Court members so they can have mentees. And we also went and visited every single LRW classroom. We presented a PowerPoint to sort of preface the experience that you were going to have. So that was a phenomenal opportunity. We also have Professor Cross, who was a major role in helping us out. And we're really appreciative of you for being here today. And we want to say thank you. I do want to briefly say what I've been seeing in the chat. There are a lot of supporters that have been watching you both and they've been rooting you on. So we actually have Farida in the chat. She said Guyana. Guyana because Farida's Caribbean. I'm Caribbean. We have the Caribbeans in the house today. I love that. Farida said thank you. She sent over a heart. Jacqueline Cobb, she was one of the judges. She said, it was a pleasure judging all of the talented NSU law students whom I have had the pleasure of judging. I also loved the live stream. Thank you for your invitations. Keep up the great work, everyone. That's awesome. We have Dakota Alvarez. She said, amazing job, Brandy and Nick. Brandy, you never cease to amaze me. Excellent job. Awesome. We have Mr. William Barnes. Rita again said Dean Cross. I see you. Jacqueline Cobb, phenomenal job. Great job, Nick. Styled by Ren. Maybe you know who that is.
Yeah, that's my way.
She said, great job. Nick. She has been in the show. Okay, now I know who that is. We have Mr. Peter Radke.
Oh, he was a judge.
Great job. David Linares. Great job to both competitors. Let's see. Shout out to Dean Cross, David. Tamil Burke. She said both are exceptionally composed. I couldn't agree more. I was watching and I was just like, my heart was beating profusely. Go Nick. Okay, so wifey at home, she is I just want you to know she is there. And she's like, go Nick, go Nick. It's probably like the 6th or 7th time. Brandy Adam, Ifargan said Brandy is killing it. Jake Schuster, one of our moot court members. Good luck to the both of you. And you have a lot of support in the chat. And Light, she said, win it, Brandy. Liz Rodriguez, she's so proud of the both of you. James Zawalski, one of our moot court members, he was wishing all of you luck. Matthew Lapari, Jenny Lay, and that is all for all of the comments. Thank you so much for all the viewers at home. I just got the word from inside of the judges' chambers. It looks like they have declared a winner and they are currently double checking the scores. So
Almost there.
we're almost there. Let me go ahead.
I'm so glad I'm not in that room. I would not want to have to pick a winner.
Professor Baxter, do you have any final comments?
My only final comments are, wow, I am completely blown away by how amazing you both were. And this is just indicative of the competition this weekend. So you can just see the kind of talent that we have, and I can't wait for next year. I already have places for you on teams, okay? Jordan and I are talking about it. She's our executive justice of teams. We already know we're replacing you. So we hope that you are willing and able and wanting to do some competitive teams and compete against other schools because
It's fine.
it's fun.
It's fine.
And we think that you guys are gonna kill it. We just can't, I'm just so blown away by that. I'm so glad, I've said this like 5 times now, that I'm not in that room. Because I would not want to be making that determination between the two of you. You were both so great, such different styles and fantastic attorneys. I can just see how much work and preparation you put into it. So with that said, let me go, yes.
The moment of truth.
Yes, so I'm going to turn it over to our chief judge, Judge May. We're going to provide brief feedback for the competitors, and then we will be announcing the winners. Judge May has the honor of announcing that. So I'm going to turn it over to her. We'll get started.
I think we'll review our critiques first. I'll just start off by saying amazing performances by both of you. And Mr. Judge Shepler.
Thank you. Mine are going to be very short. I had the opportunity to see a number of you before, and it's really impressive what you guys can do, all of you. The only thing I suppose, remember to stick to the record. Sometimes the record it can be somewhat vague. We all understand that, but your job is to stick to the record. Exactly, and our job is to be bound by the records, to make sure that your answers aren't, or sometimes the things that you say are kind of, they include more than the record says, and you want to make sure to do that. Also, when you appear before the court, you're doing it at the court's pleasure. You filed your motions, and I think that's great, but you're not necessarily going to get a hearing. And if you do get a hearing, just like if you're in the appellate arena, that's at the court's discretion. So you want to make sure that not only that you're prepared, which is true, I mean, all of you do that, but that you don't abuse it by talking too long. When you get asked questions, you're stopping, and all the things that we all learn in law school. There's a reason for that. You have a limited amount of time. The court has got things that they're concerned about. In that time, they're looking to you as an officer of the court to answer the question directly before you move to something else. So it's really important that you do that. I thought it was tremendous. Let me pass it to Benji.
Oh, I was just amazed at how good you both are. I'm so thrilled for you that you are now part of this esteemed heritage here at Nova. So congratulations on that. A couple of things. I think, Ms. Permenter, you acknowledged some things in your argument today that we've been asking other competitors throughout the morning to address. I don't know how you knew that was important, but you talked about the rebuttable presumption. We asked about that question in other groups, and the answers weren't necessarily on point, but you did a good job with that. And the question about private counsel as opposed to other counsel, we've asked that question throughout the morning, and you gave an appropriate response. So that was good. I was impressed by that. Your knowledge of the record and of the case law was outstanding. And you acknowledged us when we interrupted you. You said, "Thank you, Judge," and then you answered the question. Your eye contact was good. You maintained eye contact with just about everybody up here all the time. Even when you were talking to whoever asked the question, you were looking at all of us equally. So, and I think that's important. I have one little thing, and you're not doing it now. And I've talked to other people throughout the morning about that. I'm watching you even when he's talking, because I wanted to make sure that you're respecting his argument, just like I'm watching you when you're talking, right? So the only thing that kind of distracted me was while he was talking and you were playing with the pen. May I suggest you put that pen down while he's talking? Not as you're writing notes, then write, but you're twirling it and clicking it and just kind of playing with it. So I'm watching you while he's talking. So just, if you can remember, that was my only issue. The shaken, yeah. We had the shaken legs this morning. So, Mr. Carroll, love the roadmap. Great job. There was one point at which I think Judge May asked you a question, and I don't think you actually answered the question, but it's very hard to focus on that when you're nervous and this is finals, it's a big deal, right? And then the I believe, I think we talked to you about that this morning. So the I believe, what's the I believe? Because as we told you, at this level, we don't really need to know what you believe. We need to know what your client's interests are, but not necessarily what you personally believe. So watch out on that one. Clearly do the record, clearly do the case law, maintain eye contact. But I tell you what, you're very expressive, your face, and you have a tendency when we ask a question, you look at some point over our heads. I'm not sure. It's like you're trying to focus yourself, so you're looking somewhere else. I don't know if you know that you're doing it, but maintain the eye contact. I know you're thinking, right? And it's easier to think when you're not making the eye contact, but just that much mindful. But other than that, you guys were brilliant. Absolutely brilliant.
A lot of the same points. It's tough to really nitpick. Both of you did the record well, the case as well. Whenever we ask a question, you respond, yes, Judge, or no, Judge, and then give your detailed response. It was difficult. I would say just two things that I would try to work on, because you're going to be doing future competitions, which would be exciting. You're a little quick, Randy, just a little quick. And I had the same issue when I started. You can ask Professor Baxter. I would speed through. You're excited, you know it. You want to get it all out there. So just focus, just take a deep breath before you start answering a question, because that's really when the adrenaline starts pumping, because you're thinking your mind's going 1,000 miles an hour. So just take a deep breath and you can go into it because you know the answers. And so that was never the issue. And I think when she mentioned that, I believe that's the first thing I wrote down, because that was really the only critique I could find. Everything else was very, very much on point. You responded with our questions, great. You maintained composure throughout. I mean, it was a hard choice. I think we can all agree to that.
My only feedback, wow, and thank you. Thank you for your hard work. Thank you for dedicating yourself to this process. It is evident in every word that you said at this podium, how much time and energy and work you've put into this. You should be so proud of yourselves, and I cannot wait to come back in a year and see what you two have accomplished and what the university has accomplished. So congratulations.
So bringing up the rear here, I will just echo the sentiments of my colleagues on the bench. Fabulous performances by both of you. Couple little things. I also speak very quickly, and I used to always write S/D at the top of my page to remind me to slow down. So that is something I've always been guilty of, and probably still am. Wonderful eye contact, both of you. Wonderful demeanor in the courtroom. Ms. Permenter, you were really passionate about your client, which is what you should be. You've got the defendant. So it was clear that your passion for what you believed in supporting his position was there. You were very persuasive by that because it exuded out of you as you spoke. And so it was a wonderful performance. And you really made a lot of responses directly to parts of the record, not just it's in the record, but you could cite to line and page or affidavit, something like that. So it's clear that you really had a good command of the record. And Mr. Carroll, also, I don't know if I noticed you looking because I was in the center, so I just don't know how tall I was at the moment, so I didn't really notice that, but great eye contact. You have just a cool, calm way of being. You were kind of the yin and the yang.
Yeah.
In a lot of respects. And I don't really know or care to count how many times I've judged the card competition in the 41 years since I graduated from this law school, but this was the closest matched competition I think I've ever seen. So we all had a difficult time. We would love to give it a tie so that you could both win. I will tell you that it was a split decision, so it was a good thing there were 5 of us. But the win today goes to Ms. Permenter.
Potential feud in the making here. I don't know about anybody else, but wow. Yes, well, that concludes our presentation for today. Congratulations to our top 2 Feinrider champions. Thank you again to our panel.
Right?